Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I want to welcome you to today's webinar on understanding the statute of limitations. The statute of limitations is not something that collectors can overlook, but it is not always something easy that is to determine. Different states have different statutes for different types of debt, and I don't think I could get different one more time in that sentence, so I'm going to end it there and just say it's tough to determine which statute applies in different cases. So today in this webinar, which is being brought to you by TCN, we have a panel of experts to share their insights and advice to help you determine which statute of limitations may apply in different circumstances. Before introducing the panel, I want to take a quick second and talk about the accountsrecovery.net free Slack channel. I did just put a link in the chat window for everyone to click on and join. If you haven't already done so, it's completely free, doesn't cost you anything. We're up close to 500 members now on the channel who are using it to sort of stay in touch with one another, interact and network, and just sort of keep updated on what's going on. So I encourage everybody to join if you haven't done so already. Now let me introduce you to today's panel. Dennis Barton is the owner of the Barton Law Group in St. Louis, Missouri, which specializes in collection and defense services for members of the arms industry. His firm represents collection agencies and creditors filing collection lawsuits in the states of Missouri and Illinois, and he defends against consumer lawsuits nationwide. He graduated from the Indiana University School of Business and Washington University School of Law. He is a past president of the Missouri Collectors Association, as well as the ACA State Compliance Chair for the state of Missouri. Dennis is a member of ACA's MAP Committee Education Council and holds a prestigious title of ACA Certified Instructor, enabling him to teach all core curriculum programs associated with industry designations. Catherine O'Brien is the General Counsel and Chief Compliance Officer at United Holding Group. She is an RMA International and ACA International Certified Compliance Professional and has done frontline collection litigation and FDCPA defense work. Britt Settle works in the Pennsylvania office of Barron and Newberger. They are a member of the firm's Consumer Financial Services Law Practice Group. Prior to joining the firm, Britt was a shareholder at Burton Neal and Associates, where they served as the firm's Director of Compliance. In addition to their litigation experience, Britt is experienced in the creation, implementation, and administration of policies, procedure, and compliance management systems. Britt's litigation experience includes defending collection agencies and law firms in matters dealing with the FDCPA, TCPA, and FCRA, as well as state consumer protection statutes. Their non-litigation experience includes the handling of regulatory complaints and civil investigative demands. Britt is a current president of the Pennsylvania State Creditors Bar and a current member of the board of directors for the National Creditors Bar Association. The format for today's webinar is going to be a panel discussion. We encourage everybody to submit questions, and we'll get to them during the course of our conversation today. To submit a question, please either enter it into the Q&A tab on your Zoom webinar control panel or send it to us through the chat module. Since our panelists are going to be talking a little bit about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area. It should never be used to replace the advice of your own legal counsel. With that, that guarantees that our panelists can't bill anybody for anything. So we're going to start our conversation now. So we're going to start because some of us might not know, and I say us because that probably includes me, what a statute of limitations is. So we're going to start by talking about what is a statute of limitations and how it's applied to debt collectors. And I'm going to pick on Dennis first to give us our definitions for today. So Dennis, take it away.
Because he's the best dressed. When it comes to statute of limitations, there's good news and there's bad news. The good news is that in some ways it's very simple because it has a singular focus, meaning it has one thing that it does, and that is to prevent you from filing a lawsuit, not prevent you from collecting, not prevent you from talking about the debt, but prevent you from filing a lawsuit on the debt. That's all it does. Now, the restrictions the FDCPA places on that, the courts have placed on that, become very complicated. But what a statute of limitation is and what it does is pretty straightforward.
Okay. Anything?
Correct. Judges have said I'm correct. That's good.
I would add that statute of limitations is actually an affirmative defense that traditionally has been forced. You have to affirmatively plead that or it's waived. And I think that in the world of debt collection, it's gotten turned around a little bit and is used now more of a sword than as a shield. And I think that can cause problems in a variety of ways. If you are in a personal injury lawsuit, you can't sue the attorney for, because they filed outside the statute of limitations. But with a debt collector, you could. If an attorney files a claim beyond the statute of limitations, then a consumer gets to sue them under the FDCPA. So I think that's what makes it a little different in the area of debt collections.
And just to clarify to that, the reason it is an FDCPA violation in our industry is because it's a misrepresentation of our rights to collect out of the debt, saying that we can
The
collect
legal status of the debt.
Yeah.
Under 1692E.
Yeah.
Correct.
I think it also, although it completely applies to filing a lawsuit, it also applies to collecting on time barred debt. You need to know that the account is in fact time barred so that you apply the proper disclosures or, the scripts on collecting and on that debt. So I think knowing that date is obviously, you definitely need it for filing a lawsuit, but you also need it for, the continued life of that account. Because believe it or not, you could potentially get sued if you say an account is at a stat when in fact it is not at a stat. So it works both ways, unfortunately.
So Dennis, how simple is your answer looking now? Now that we've all mulled it over and chewed on it for 7 minutes.
Well, so that's the bad news part. The bad news is the application of it's very complicated, but what it is in general, the purpose of the statute is pretty straightforward.
Totally black line. Yeah, and I mean, all the different types of debt too, right? There are different causes of action too. Obviously, every state is a unique special butterfly and they have their own rules. And even the UCC we were talking about beforehand sometimes applies. So it's really very complicated to figure out exactly how the statute of limitations is going to affect your specific account and then multiply that by 10,000.
It is really complicated. So Catherine, I know you're actually general counsel at your agency, and so you're in-house. What about, and as an outside attorney, and Dennis is probably an outside attorney, so we tend to always think of statute of limitations as a determination of law, right? You got to read the statute, you got to figure out what cause of action you're going to bring. How do you, I guess I have two questions. How do you, as an in-house general counsel, go through that process? And then two, do you think it's different for non-attorney compliance officers?
I'm actually a passive debt buyer. So I have to work with my agencies and make sure my agencies have the right, programming or the law firms. And it's tough because I might be more conservative and say, or maybe I'm not, and say, oh, I think the statute of limitations based on my research or my expert counsel is this year. However, the law firm who, they're actually out there doing this and they're the ones who should be more familiar with their specific state law, they might be more conservative, especially when it comes to certain counties. I'm sure Dennis knows this. There's some counties that, quite frankly, it's going to take you an extra 6 months to serve a person. So you have to pad that into your calculation, and maybe it's a lot shorter. And that's why I always say, be careful if you think it's not legal eligible. That's a little bit different than saying it's out of stat potentially, especially with some of the programming that goes back and forth with your agencies and your law firms, because just because you won't sue the account doesn't mean it's time barred. It just means you don't have enough time to properly get it filed, served, and whatever you need for that specific county or state. So that's why even if you have the right date, it might not even, you can't always push it to the day of. You have to factor that into your practice. So even if the statute of limitations is going to expire next week, you might already be out of luck, unfortunately. So that's why programming, reviewing your matrix at least annually, making sure that you have everything up to date, and really checking out your reporting is so crucial, because if it takes you an extra 7 months to file in one place, you need to know that so that you're not losing out on accounts. Nice practical tip for you guys out there.
We got a question here from Richard asking, if there's a debt, someone rents a product and a widget, and then stops paying for it, when's the statute start to run? Is it on the date the contract's written, the last payment date, or something else? And part of that's going to be a state law. That last payment date is a big part of it. But really, keep in mind that it's when the debt is incurred. So when the contract is written, really doesn't matter. It's when the debt was incurred. And if that's the date of the contract, that would be a big determining factor. But it starts when you start to owe the money. And then the last payment date is important, because in some states where it restarts the statute of limitation to have a payment, when a payment restarts the statute, then it's going to be the last payment date. Because again, it's all about how long do I have to file suit? And that clock starts differently depending on your state law. So if your state law is like most and a payment restarts the clock, then it's going to be the last payment date.
However,
Well, and
the last payment date, you want to make sure that it wasn't like an NSF, not sufficient funds. And maybe there are some states that a partial payment might be okay or might not. Partial payment means if your minimum for a credit card, minimum amount due was $50, but they only pay 25, then that's not the last payment, even though it might show up on your records. And then what maybe there might need to be a written promise to pay associated with that partial payment in order to toll it or not toll it. So it gets complicated based on your state. And that's why it's so important for our meaningful attorney review when they're looking at that actual account documentation to really check out and see what was the last payment, or maybe it's transaction. The last transaction too might be the deciding date. So it varies across the country, unfortunately, but the last payment is always kind of, was it a real last payment?
well,
worried.
I'm sorry, I thought you were done. And I think it's going to depend. I mean, in the example Richard gave, it looks like he says rent a widget, but then he's talking about collecting on a past due debt. So renting is a lease in essence. So does that mean that the creditor has has a security interest in the collateral, and that might mean a different statute of limitations? So it's going to depend exactly on what the underlying basis of the debt is, and as well as what type of cause of action the attorney wants to bring, or what cause of action you could bring. So for instance, there are some states where, a breach of a written contract might be 6 years, but in an implied contract, so an unwritten contract, for instance, is 4 years. And if it's a credit card debt, what are you going to file it under? Because some states might say, oh, it's 6 years here, and other states are going to say, no, it's actually 4 years because it's an implied. And again, that's going to depend on, well, okay, are you suing under, let's say, breach of contract versus an account stated, which, in some states is seen as an implied, contract there. So it really can get granular, and it really can be biased by sometimes a case-by-case basis. So yeah, and getting back to the meaningful attorney involvement, very important.
Well, and getting back to what Brett was, the further comment on what Brett's saying, I'm a collection attorney, first and foremost, and a lot of written possession. I do a lot of written possession, especially those in Missouri. And in Missouri, a written possession case can have, and really, actually, I should say post-possession. I don't do, we just do after if the person's already left, no eviction. But, it could be, the statute of limitation is different for the same case. For rent in the state of Missouri, a contract for money is 10 years, and rent is construed as a contract for money. But a contract for other types of services or other types of damages, such as the property damage that they still have to pay. They broke a bunch of windows and they have to pay that. Well, that's a 5-year statute of limitation. So even for the same case, for the same contract, which in this case would be a lease, you've got 2 different statutes of limitations that you have to know about and apply differently, because you may be able to go after the money damages, but you may not be able to go after, let's say, the property damage if it's 6 years after the property damage occurred. So like Brett and Kat were both saying, that's where the attorney, whether it be a collection attorney like me, or you looking at it within an agency to really review what statute of limitation is going to be, that attorney review is very important.
Yeah. So I think there was an important question that came up in the chat, going back to what Catherine was saying about filing a cause of action, and when, when you cross the line. Is it, if you file the complaint and you beat the statute by, let's say, 2 months, but then you don't serve the person until 3 months, what line is that? And I think that, and, I'll give my opinion, and then I'd love to hear Dennis and Kat's, because I think that technically you have filed, and you filed within the statute of limitations, technically. And so at that point, they have to raise the affirmative defense. Now, the flip side of that is, if I put my consumer attorney hat on and I say, okay, you may have filed it on, January 2nd, the statute ran on February 28th. My client wasn't served until March 30th. They didn't even know about the lawsuit. I think I've got a good cause of action there. So, I think what Kat was saying is, you want to build those, you rely on your attorneys to build in that time to know their specific area. Pennsylvania, some counties are great at getting service out. Some counties, you could send something out for service and not hear anything for 3 months. And so I think that that's what Kat was saying. I'm not sure there's a hard, bright line rule. Technically, it's you beat the statute if you filed it. But if you're not, again, if you're not serving that consumer until 3 months later, and in between those 3 months the statute's passed, I could definitely see a consumer attorney bringing a lawsuit on that.
Yeah, and remember, some states are served first. And
That
then there's
too.
a certain laws that each state has that if you serve them and file it within a certain time period, that's considered good. So maybe you serve them and you file 10 days later and statute of limitation runs out in between, you might still be good.
Minnesota, Washington, I think are the two that come to mind.
And also some states have very specific laws of how long you have to serve a person. And let's not forget that the pandemic has still caused, even 15 months later, there's still delays. So even if if it's a paper state, paper county, it might be sitting on a clerk's, pile waiting for that stamp. And until it's stamped, it's not filed. So that's another reason why you might want to look at your timeframes, pull some reports and see when is my statute and how long do I have? Because I know there are some small counties out there that they're just waiting to get that stamped copy. And then you have to hold your breath and hope that it got done because they're going to mail you a copy, and mail is obviously perfectly on time these days. I haven't had any problems. I'm sure you haven't either, but something to factor in real world.
Yeah, that Pony Express is working real well these days.
Yeah, but that could kill your case. And then if you filed it and it's out of stat, and that's on you if they catch it, if they raise the affirmative defense, although I'm not sure if that really applies much anymore personally. I think that
in the CFPB and the new rules, in the second edition, of course, when they talk about the statute of limitations, they specify the statute of limitations is an affirmative defense, but to the least sophisticated consumer, they don't know about affirmative defenses and all that legal mumbo jumbo. So we're just going to make it a strict liability, and they don't have to raise it as affirmative defense. It's a violation whether somebody says something or not. So, Kat, going to your point, the rules, the new rules pretty much reinforce the current law, which is you can't sue after the statute of limitation expires, period. Which,
Right.
Okay, but that's what was already in place. In fact, even absent the CFPB, there's, rules of ethics that govern, and, rules of professional conduct and just state statutes that were already in existence that you couldn't file. And lawyers would most likely be sanctioned if they did it repetitively. So
how do you protect yourself? Policies and procedures.
Well, but that brings up, I think you guys both teed up the next question. Can you rely on your policies and procedures in a bona fide error?
Well, it's always better to have them written down and then try to rely on them than to not have them written down. So if you don't have anything, now would be a great time to write down how you calculate it and how you apply it, or where you get your information. So if you do get in trouble, you can at least try for that defense. But if you don't have it written down, it makes it a lot harder to defend yourself. So, but yes, that is a great question.
yeah.
So could you raise a bona fide error defense then? If you did get the statute wrong, and let's say you got the statute wrong. Let's say it's a credit card debt, and let's say a debt buyer is the one who's filing suit, and they think it's a 6-year statute, but the consumer comes in and says it's a 4-year statute. Do you think that you guys, I guess Dennis, the defense attorney, and would you have your client claim bona fide error?
It depends. I think.
Oh, that's such a
Very
oily
answer.
answer.
Just hold on, just settle down now. The bad thing, so many people like bona fide error defense when it clearly doesn't apply. They're like, I'll just throw it in there. But the reason you throw it in there, and then you open yourself up to all this discovery regarding policies and procedures. And if you really don't want that out there, then, and I don't want my policies and procedures in the hands of other people that can then take it and try to manufacture lawsuits against me as a collection attorney. So I don't want that. So it really does depend. I think most courts look at this. If your mistake was one of law and you thought the statute of limitations was 6 years, it turned out to be 5 years, and you just messed up. Well, that's not a bona fide error. But if it comes down to maybe what was the date of the last payment, and there's some factual, some room to debate there as to the date that something actually happened. Well, that's a question of fact, and And if you got it wrong because your records were wrong and you knew the statute, you knew what the law was, and you just made a mistake based on your misunderstanding of the facts, well, that's a good bona fide. It could be a good bona fide error if you have policies or procedures in place and it was an isolated incident and it was more of a clerical error than anything else and it wasn't widespread, then yeah, I would say you use the bona fide error as a defense. But if it's kind of iffy as to whether the defense is going to work, I usually tell my clients, look, it's a business decision, but I wouldn't want to air out all my policies and procedures, and you're going to have to do that, at least when it relates to the statutes and limitations. And I don't want to do that. So
yeah, it is a business decision, but you also don't want to make bad law, because if you push it too far, you may be the reason why what once was a 6-year for everyone is now a 4-year in this situation. And that has happened, years ago. New Jersey is my favorite example, where we thought a retail card was 6 years, and then it turns out that the court's like, no, it's always been 4 years. This is how it should have been applied, and everyone had to scramble. I, for one, wouldn't want that to happen in every state if it's not clear. So it is really about, you want to protect yourself in that one case, but you always got to figure, am I going to ruin it for all my other cases?
And there's no examples of any bad laws that have been made, but
Can't think of anything in the last 2 weeks.
courts in recent decisions, in recent weeks or months. So I just want, I hate to interrupt, but I did want to pause for a quick second, and I want to say a few words about TCN, the sponsor of today's webinar. TCN provides cost-effective call center solutions for traditional contact centers, collection agencies, and thousands of businesses worldwide. TCN has continually stayed current with TCPA and CFPB changes by introducing enhancements to its core platform, one of which is TCN's natural language compliance, which uses smart algorithms to build compliance rules naturally. Simply type your rule into the TCN compliance manual, and the natural language compliance engine will build an easy to understand compliance rule. One example of a rule could be deny outbound calls before 8 a.m. and after 9 p.m. You could even type a rule that would limit 7 calls in 7 days. There's no limit to the number of rules TCN's processing engine can compute. TCN software is a platform suite that also provides built-in data management services that eliminate data entry errors, business intelligence with reporting dashboards, call recording with storage, smart IVR with payment capabilities, speech analysis and transcription, and much more. Regardless of size, location, or application, TCN can provide robust solutions for your call center and collection agency. Give TCN a call or visit them today at www.tcn.com for more information. Thanks again to TCN for sponsoring today's webinar. All right, we've got a bajillion questions that have come in, I think, and that's an exact number. So I'm going to try and get to a couple of these. One for you, Kat. Many creditors may calculate the statute of limitations differently than the firms. What is your advice on how to educate the client to update theirs so you don't have lots of accounts that get forwarded just to get closed?
I do see this a lot. I think communication is key. And if you think that it should be a certain time period versus what I think it should be, show me, prove it to me, give me the case law, give me the statute, give me anything you have as to why I might be wrong or I might be right. And I think I view my service providers, we're partners in this. Neither one of us wants to get sued, and we both want to do this properly. So whenever you see something, you just got to bring it to your client and say, can we review this? I think this might be wrong for this debt type, and here's why. And I've seen, one of the other questions was, is there a chart? Yes, there are dozens and maybe even hundreds of, everyone has a chart on how to calculate this, broken down into the debt type and into the state and the county, and everyone's is unfortunately a little bit different because there is no real right answer. It really depends on your specific account sometimes. And you really have to look at it. And that's why the attorney meaningful review is so important at that end game, where we can program and we can think, okay, this one debt type, I have case law, I've got a great statute, it's right on point, let's do it. But then, something comes up and it makes you stop and think, oh, maybe this isn't applicable here. So yeah, there are charts everywhere. I have like 7 of them, and I compare them all the time and try and find why I think the right answer is right. But yeah, sometimes the programming does conflict, and I say 5 years and you say 6 years. So what do? Do you go conservative, or do you have a really good reason why 6 years is right? And again, I think that's really important to pull those reports. And if you're going to sue someone, like make sure that you're checking your time periods and give yourself plenty of time to have that attorney do the meaningful attorney review. Make sure they have all the documents and everything they need to sue, because if it's going to take you 3 months to get ready to sue, you might blow your window.
And tying into your policies and procedures, Patty asked a question about choice of law, but the FDCPA, they're not big on choice of law provisions. So, and you, Catherine, Brett, you can disagree with me wrong.
So
But
Dennis, what is a choice of law provision?
Yeah, they don't find those enforceable. They don't, venue provisions, they don't find enforceable. So I'd be careful with that.
Yeah,
So,
choice of the borrowing statute. These are very complex. Britt, please.
Yeah, I was gonna say, just so a choice of law provision, for instance, I'll take Citibank credit cards. They have a choice of law provision. They say they apply the law of South Dakota. So what does that mean if I want to, I'm in Pennsylvania, what does that mean if I want to file suit in Pennsylvania? So in theory, I could say, oh, South Dakota's, I'm making this up. I don't know what the statute of limitations is in South Dakota.
Let me check a chart. Hold on.
Oh, okay, great. So in Pennsylvania, it's 4 years. Let's say in South Dakota, it's 6 years. And what does that mean? Does that mean that I can say, oh, I'm going to take the 6-year one I know what it is in Pennsylvania, it's 4 years. I mean, you have that argument. Courts don't look, especially with consumers, they don't look very favorably on that. They don't, a lot of, state court judges, they're overworked. They see thousands of debt collection lawsuits. They don't want to go through a rigorous choice of law analysis. So it's really up to you. I think, in some cases you may want to decide which is the more conservative one, and maybe you want to go with that. So for instance, several years ago, it's been a long time now, but there was a case actually in the Third Circuit where it was a Pennsylvania consumer, and it was a choice of law provision that's in Delaware, which is another common one. And the Delaware statute of limitation is 3 years, just like Catherine said, I know that. In Pennsylvania, it's 4 years. And so they sued under the 4-year belief. And then 3 years, the consumer said, oh, it's 3 years. And the court, because it, was a federal case, because it was an FDCPA case, the whole argument with using the 4-year one became, well, the person never availed themselves of Delaware. And it became this whole rigmarole. And what the court finally decided was, I don't really care. They sent their payments to Delaware. I'm choosing Delaware. So, I mean, sometimes you can go through all that analysis and spend all that time when at the end of the day, you may have been better off just choosing the more conservative statute.
That's right.
Because
It's not
people's
your
head-
choice of law. It's the court's choice.
Yeah.
Because people's heads might not be spinning enough. Let's talk about medical debt now, because there are a bunch of questions that have come in about medical debt and how to calculate the statute of limitations there. Does anyone have any rule of thumb? Is there any chart to help out with that?
I'll tell you, when
probably
I
several
collect a
charts.
lot of medical debt, and I can just speak for Missouri and Illinois, we take it on the date of service. Is when the clock starts for those two states. And for both states, once, if a payment is made in the meantime, then I used the phrase before, restarts the clock, meaning the statute of limitations starts over. Somebody asked a question. One of the outstanding questions is, what does that mean to restart the clock? Well, if there's a 5-year statute of limitation, and year number 4, you make a payment, well, we're right back to the 5-year statute of limitations starting back on the date of your payment. So thank you for your payment.
And with medical debt, I think my first, rule of thumb would be, go find out if that state has a specific statute of limitations for medical debt, because some states do. And so you can't work under, they signed up for services or something like that. So, even if you go from date of service, but you think it's a normal breach of contract, but your state has a special law that says medical debt is 2 years, you thought it was 4 years, oops. So yeah, I mean, I think Dennis's rule of thumb to go by the date of service is excellent. And I think then I would make sure that to find out if your state has a specific statute of limitations. I know, for instance, they just passed one in Nevada. And it's becoming more popular as medical debt kind of becomes a key issue in the nation.
Yeah. I know there are a lot of questions about like payments and how it makes, and I know we've said this, but it really does depend on your specific state, where the consumer lives, and potentially where the contract, was signed, where the service happened. All those factors come in to determine whether or not a payment starts it over again or doesn't. Like I said before, the partial payment might not actually do anything.
Or in some states, or a partial payment does revive or restart the statute of limitation. It only does it if the statute of limitation has not yet run. There are some states where you got a 5-year stat and you're in year 6 when a payment is made, voluntary payment, it doesn't do anything. And I don't have that chart or that list with me, but you got to be careful of those states. And also,
And
real
there are
quick,
some states-
what a payment is often, and Kat kind of touched on this earlier, what a payment is sometimes not super clear. For example, a lot of times courts consider a voluntary payment. Missouri is one of those. However, I think it's 2, maybe 3 years ago, there was a case decided in the Missouri Supreme Court that a garnishment is a voluntary payment. Okay, so every time we get a garnishment payment, it restarts the clock. On the statute of limitation for that judgment, I'll be more clear. But my point is that what a payment isn't always as clear as you think it is.
That's actually another good point. Once you have a judgment, there's a whole other chart that applies for how long the statute, how long that judgment's good for. So when we talk about the statute of limitations on time bar debt, we're talking about pre-judgment files. How long do you have until you can file? But once you get judgment, then you have to have a whole other programming to say the judgment's good for 5 years, 10 years, 20 years. Forever, who knows?
Do you have to how long is the judgment good for? Do you have to, can you re-up the judgment if the judgment is only good for 5 years, or at the end of 5 years, are you only losing priority, but you can still do a garnishment? It's kind of like, those choose your own adventure books. If you blah, 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 go to page 94. If you, that's what it is. If you don't have a judgment, go to page 86. If you do have a judgment, go to page 102.
Have you done anything on the judgment? If you haven't, then it's a dormant judgment. But if you've done something, then it's good for another 5. Yeah,
exactly.
There's a question in here, and I feel like we're kind of scattershot a little bit. So forgive us for that. It's just one thing often leads to another, which leads to another. And one of the things we've been talking about is the bona fide error came up, and somebody had asked, David asked a question about, well, what if the law is unsettled? I don't think that matters. You're going to find out if what the court thinks when the lawsuit's filed against you, and whether it agrees with your interpretation or not, and what you've been doing or not. Because I think it's a lot of other things. In any minute, the appellate court can just change on a dime. Like, you know what? We were always saying the statute of limitation was 5 years, but now we're going to say it's 3 years. And for all those of you who've been filing lawsuits or are now violating statutes, tough.
Well, but that's an interesting question, because I think if the law is unsettled about what the statute of limitations is, and you have great legal arguments as to why you think it's X, Y, and Z, and your policies and procedures back it up, and you have, you're willing to fight that, I would urge you to fight it. Because look, there's a recent case out of the Ninth Circuit. It's Kaiser versus Cascade Capital, I think it is. What they did, and this is the Ninth Circuit. So this was I found this to be pretty interesting. The Ninth Circuit basically said, so the debt collector got sued allegedly for threatening, for suing beyond the statute of
what they thought,
for suing beyond the statute of limitations, and it was both the Cascade Capital and then their debt collection law firm got sued, and they said, well, hang on. And they went through this whole analysis of why their statute of limitations analysis was correct. And the court, now traditionally under a Supreme Court case German, you cannot rely on a mistake of law for a bona fide error. Now the Ninth Circuit has said, in this particular situation, where the underlying FDCPA violation is a 1692E violation, that supposedly they filed suit beyond statute of limitations, it was misleading, deceptive, all that jazz. The court found that because it was a mistake in the time barred status of the debt, that it was a collateral element of the offense. And so they took that as a question of fact and a mistake of fact. And they specifically say that on page 21 of the slip opinion, which I think Mike just emailed out or put in the chat. Thank you, Mike. Now, so there's that Ninth Circuit case, which is really fascinating. Now, if you want to look at an older case that goes through a very rigorous analysis, which I think is an excellent example of how you could litigate a bona fide error issue. I'm not saying it's a slam dunk. I'm not saying it's going to work. But it's an interesting case out of, I believe it was the Eastern District of Washington. It's called Sattel versus Gray, or excuse me, Gray versus Sattel and Associates. It was my dad's law firm. I wasn't involved in it, but it was my dad's law firm. Yeah, I know. How many Sattels in debt collection are there? So it was my dad's law firm. It's probably the case that made him retire. But the court went through a fascinating analysis of everything the attorneys at Sattel and Associates, who are the owners now, Karen and Isaac Hammer, everything they did for the statute of limitations and the analysis and the comparison of the charts and all that. And the judge says, you know what? I'm going to grant them the bona fide error because look at all the work they did. I can't even figure it out. So that's another interesting case too. But other courts have rejected it under the German analysis of, you screw up the statute of limitations, that's a mistake of law, you're not entitled to bona fide error.
Yeah. Oh, going back to medical debt, where we were talking about, somebody asked a question about insurance.
I bored you, Dennis. Back to
No. I think we're kind of left with, it's a very good analysis, and I agree that that's one of the roads that a court may follow. But I still fear that a court's going to say, was this fact or was this law? And if you got the law wrong, even if we are clarifying our interpretation of what the law should be, if you wound up on the wrong side of that, as universally unfair as that may feel and sound and be, I think you're just gonna. I don't think the bona fide error is going to be an available defense, at least in the eyes of many courts. But going back to the question on the medical debt, somebody's asking about payment, and when insurance pays, is that a payment? I would say yes. I'd like to hear what Kat and Brett think, but it's just somebody's paying on your behalf. It's like your mom paying, I would think, on your behalf. Not that my mom pays my medical bills anymore, but just saying it'd be like anybody paying for you. So what do you guys think?
Well, would that be an insurance payment that's made 4 years later on the account though? Or one that's usually made within 6 to 12 months? Because I know there's some states that are factoring that in specifically into their statute language, where it says an insurance payment can be made, and maybe it's even giving a time frame of within 6 months, so that after 6 months, if the insurance hasn't paid and they haven't paid, then you have a green light to go. Or I know there's pending legislation in a couple of states that they're trying to factor that in because it is complicated and it does add that wrench of, well, which payment do I use? I do agree that a payment is a payment. So if it's from an insurance company, it should count towards that account. But again, you always have to look at your specific state and whatever specific debt type you're looking at, because there might be a statute right on point. And also, get involved with this legislation sometimes, because these can affect everyone, because these states could be trend setting. California and their new sort of mini CFPB. You got to be aware of these things, and maybe it means you go down to your local legislative, you testify to your Senate or go out there with a placard, no SOL.
Join your state creditors bar associations, join your state collection associations.
Yeah.
SOL just doesn't stand for statute of limitations in that case, does it, Kat?
That's exactly right. Thank you for picking up on that. So there's a question about collecting on out-of-stat debt, and is it worth it? I think it is. I think there's still venues you can use. You can still call people. You can still letter. You may potentially still be able to credit report on the accounts depending on the timeframes. So I think there is still value. And if they were to just get rid of out-of-stat collections, like I know the CFPB contemplated it in their new rules of just saying, nope, we can't do it anymore once it's time barred. But then they couldn't really figure out a clear rule on how to figure out if it's time barred. So they kind of said, never mind, just keep going. I still think there's value in it. And I think that if they wipe that out, it would really affect, credit in this industry and actually hurt the consumers, because their credit worthiness would be really factored in. They wouldn't be able to get these kind of accounts because the risk would be too high. So I support out-of-stat debt as long as, you think you have the right date and you have all the disclosures you need for that state, where they live. And if you are calling, you have the right scripts for each jurisdiction. Do you guys have an opinion on that?
Yeah, I think, in my prior life, growing up in the world of legal debt collections, literally, And actually having done that, as an attorney who did debt collection, I was like, out of stat, nope, stay away, third rail, no thank you. And that would still be my advice to any law firm that's on the call. Third rail, pass it back, not your job. Flip side, on the agencies, I agree with Kat. I think there is room and there is space out there for that, but you have to be very careful how you do it, just like Kat was saying. And you need to be aware that there are certain states where once the statute of limitations has run, the debt is actually extinguished. And that means you cannot collect on it. The debt goes poof and has disappeared. Okay, so we had talked about statute of limitations being an affirmative defense at the beginning, of our discussion. And that's true, but there are a handful of states where as soon as that statute passes, the debt's gone and you cannot even attempt to collect on it.
They call that the creditor's rights and remedies expire. That's the phrase you want to look for.
That's Mississippi, North Carolina, Wisconsin, right? And North Carolina's for purchase
Debt
debt.
buyers only. I believe that's correct. Yes.
I know that because I read it like 3 minutes.
But we're not your lawyers. Seek your own counsel.
Yes, seek your own counsel.
That could have
But
changed
if you
from
do
this
follow
morning.
Dennis's advice, just remember it was Dennis's advice.
Hey, real quick, I want to say I love this question. Is it worth it to still collect on out-of-stat debt? And the reason I really like it is because it goes to what everything is. It's a business decision, and you got to look at it are you going to make money? And is the money you're going to make is going to outweigh the risk that you're going to take? In my opinion, if purchase debt is a big part of your portfolio, then it's most likely worth the risk. But if it's a small part of your portfolio, it may not be, because all of the inconsistency and all the added notification requirements you have with letters and phone calls and now potentially payment portals and websites, I don't know if it's worth it if it's a very small part when you have growing exposure, because the trend is going to more disclosures in more places or more people, and if you're not making that much money off it in the first place, I'd stop that, unless it's something you have to have because your client won't give you the good stuff without taking the out of stat stuff. But otherwise, if you have a choice, I probably wouldn't do it if it was just a small part of the business.
And it can be profitable. It's not as good, but there is some profit to be made if you do it right, of course. There was one question about what if a consumer calls in and tries to make a payment, a voluntary payment on a time bar debt? Can you accept that? Again, it kind of depends on where and when. I say yes, as long as it's very clear that they want to pay the specific account. Some states you may have to tell them, you do know that this is time barred. Then they say, yes, I still want to pay it. And you say, thank you very much. I'll credit it to your account. But that, again, it kind of depends on where you are. But for the most part, I do think voluntary payments can be accepted, even if it's a closed account, time barred. They want to pay it. A lot of people, a time bar debt is really kind of almost like a moral obligation to people. They want to do the right thing, and they just couldn't at the time, and now they want to because they can.
Well, and going to that, somebody asked a question about what if they just paid $1 on this debt, $10,000 debt, let's say, and he paid $1. I don't know of any statute, at least in Missouri and Illinois, that says it only restarts the stat if it's a certain, percentage of the bill. I think a penny restarts the statute of limitations. I don't know about other states.
Depends on the state.
Yeah.
Yeah. If they have a written promise and a partial payment would be it, or if they have to actually write like a letter saying, I promise to pay this off, even if it's 1 penny at a time.
Yeah.
Then yeah, maybe they did restart their own debt. And again, it depends on your company policy or your client policies. A lot of clients don't want to take on that risk. So they may have a policy that even if a payment would restart it, they don't care, just close it down. Yeah. So it depends on your client too.
Or some clients won't, some creditors won't restart the clock. I think that's the same thing you were saying. Like, okay, take the payment, but that's not going to restart the clock for us, even if state law allows it. They'll just say, you know what, 4 years, we're done.
I don't have any of those clients. All my clients want as much as they can get, when they can get it, how they can get it.
Until they get sued, and then they'll be a little bit more careful.
And just to clarify, the question about making a payment was, what if the debt collector made the payment on the debtor's behalf?
So Dennis and I have actually talked about payments versus creditors, like a credit on your account or like refunds. And I think a payment, a voluntary payment is a payment. And if you happen to credit the account or you realize, oh no, maybe this got charged twice and you're trying to fix it to the benefit of the consumer, then that does not, I don't think that affects statute of limitations at all. And you really have to be careful of your programming, because if your accounting department accidentally posts a check to an account and then they fix it, you got to make sure that that doesn't adjust your timelines, because I don't believe that accounts.
I think there's a Missouri Supreme Court case that's what the creditor did. They was like, well, we gave a credit of $5, and so we restarted the clock. And the court's like, are you kidding me? No, you can't do that.
I would not personally want to defend that one. No.
That's a too good to be true sort of thing. No, it wasn't true.
All right, I'm trying to get through some of the questions here because our panel has done a good job of answering a lot of these. Here's one. How do you address this scenario? You file a lawsuit timely in attempt service. You are unable to effect service timely and the matter is administratively dismissed without prejudice, subject to restoration for moving to reinstate your case. Are you risking attempting to collect on an out-of-stat debt by reinstating the case since the action, I already see heads going up and down, since the action was technically dismissed? How do you protect yourself so you can engage in those necessary actions to reinstate your case, which any other non-debt collector attorney could do, while balancing against a claim that you were seeking to collect on an out-of-stat debt?
So I'll go with the most conservative approach, and I'm sure Dennis or Kat will push back on me. But as the attorney, I would say no, don't refile it. It's been dismissed. You're now outside the statute of limitations. Too bad, so sad. Hand it off to what?
Your SOL.
Yeah, your SOL, exactly. So I would say no, return it to the client, and then if the client decides, to hand it off, if they have an out-of-stat person, great. But I think generally, I think it's risky. There's even a comment here from Mr. Natkins who says, Ohio has a savings clause. Well, that might be nice and all, but do you want to, if it's a $2,000 bot debt account, do you want to risk an FDCPA lawsuit on that? If it's a $10,000 account, maybe you want to, he says yes. Yeah, maybe he wants to, maybe you do want to go after it, but, I would just say not worth it, not worth the risk, lay it down.
I agree with you. However, just for fun, I'm going to fight. It's actually kind of an interesting year. There are about 8 or 9 states out there who have very specific pandemic policies extending the statute of limitations for a short window. So this 1 year, you might be able to work in that because of the delays or because of the pandemic shutdowns, that you might be able to buy yourself a few extra months. I personally wouldn't do it, but it's out there if you really have a good case that you want to fight. And
that's a really good point, Kat.
If you have these cases, I know there are, like Mr. Natkins was saying about some states, like I think Georgia does too, where they have certain filings that you can dismiss it and then still hold your time, the tolling. But also, if you have a case, you can file documents, ask for more time for service. There's also motions and stuff. If you're really trying to save it and you want to babysit that one account, there are judicial ways to buy yourself more time, unless the state has a very specific, you got 6 months and you're done. Serve them or you're done. So again, it depends on your state.
Ladies.
Don't be a lady.
Let's be very comfortable in life, but I and my clients, we need that money. We need to get the debts paid. The creditors need the money, and so we in these many states like Illinois, Missouri, at least it sounds like Ohio as well, where there's a savings statute, and savings statute, just so we all know, means that. So if you file a case within the statute of limitation and it gets dismissed without prejudice for any reason, you have 1 year to refile. And so if you've got 1 year to refile and it won't violate statute of limitation, which is what these savings statutes are all about and why they're in place in the first, why they exist in the first place, then I advise my clients, in fact, I will tell you, my firm does, we file after the statute of limitation is run, as long as it's within the savings statute time period, because that has extended the statute of limitation. So while I guess there's some theoretical risk, this is a risk. You have to be somewhat risk tolerant to be in the industry in the first place. So my clients and I have agreed that we file suit when we can, And when there's a savings statute, you can.
And that goes back to the meaningful attorney review and why it's so important that your, the boots on the ground attorney that is filing this case knows their state law, knows the situation, and has looked at the actual documents to make sure there are no choice of law provisions in some contract or, something to kind of throw a curve in there. Again, it depends on the debt type. It depends on the state. It depends on contract provisions. What date to use, and are there any tolling particulars like the partial payment? All of those things have to be factored in for every single case.
And David made an excellent point, by the way. He said, be careful with savings statutes because, Missouri made a good point that there are some claims where you can't do that. And in other places like Kansas, you have to be, so you have to serve the consumer before the statute of limitation date. So he makes a very good point that, again, just like everything else we've talked about today, there is no cut and dry answer as to the statute. Or probably, let me rephrase that. There's no, every state gets the same answer sort of thing. It's all different everywhere.
And as we learned a couple of weeks ago, just because the way you read a statute doesn't necessarily mean that it's a correct. So you always have to be careful. But it's navigatable. You can sue on these accounts. You can do this. You just make sure you have a good attorney, make sure you've reviewed it, and always keep checking it. Keep reading Mike Gibbs' newsletters for up to the date information on whether the laws have changed or if a case is coming down, specifically attacking a debt type in a state, saying that maybe it's not what you thought it was. You got to always keep. This isn't just something that you put in place and then forget about.
Absolutely not.
Yeah, it should be a living, breathing document.
Well, I've been working on a chart since we started.
7 years everywhere. No, I'm just kidding.
That's what I've gotten from today. And actually, we did get a question in asking, where do you go to look? Obviously there's different interpretations, different plots, but where do you go to look to find a state, what the state statute is on collecting different types of debt? Is there a general spot to go to look?
Well, it's nice that you've asked because ACA International has a great service called Search Point. And on Search Point, there is a statute of limitations section, and it gives the laws of all the states. In fact, I've looked at it recently on a couple things, and it's spot on.
I agree, and I'm going to disagree. ACA, it's a great starting point. I've looked at it recently and found that they actually misstate the statute of limitations for several different types. So you may want just check the date of when it was last made, and then just go, because on the ACA, they'll tell you what the statute is. You can go look it up. You could, probably just type it into Google, or if you have access to like LexisNexis or Westlaw or any of those other ones, you could type it in there and find that out. But that is a really good ACA. It's a good starting point. And I would just say trust but verify, because I have found errors, with particular types of debt very recently.
Yeah, and there are so many different types of debt. Your account might be a little bit different. You think you have a normal credit card, but maybe it's a retail card versus a bank card. And by that, I mean, retail means you go to a store, like a Best Buy, a card that you can only go to Best Buy and buy goods for. So that might have a different calculation. And ACA, I agree, the chart is great. Sometimes it's off a little bit because of the specific debt type, which is specific to your practice. So yeah, trust but verify. Love it.
Another question, I don't think we've tackled this one yet, looking at memberships. So if a contract is signed January 1st, 2016 for a service such as a membership, the account does not go past due until January 1st, 2020. When does the statute start? Does it start on the date of it first went past due? And it's an Oregon contract for anyone.
Meaning they paid the contract up front so that they have service for 6 years right from day one. It's a great contract. Then it would be after the date of due if they haven't re-upped it and it's supposed to get paid in 2020. Is that it? I think I may not understand the question. I apologize.
I think that's the question. Yeah, if it goes to, if it's been in effect for 4 years but doesn't go delinquent until 4 years later, when does the statute start?
Well, it starts on the date the debt is incurred. The statute starts whenever your debt starts, and it doesn't matter when the date of the contract is. It only matters when the date of your debt starts. So if the contract's 4 years old, but you've been making payments, consistent payments for 4 years, and it wasn't until 4 years in 2020 where you stop making payments, then that's when your clock starts to run. Statute of limitations time period is from the start of the debt to the end of this statute period.
And I know a lot
Typically
of
it's
people-
called,
Go
I'm
ahead.
sorry. Typically it's called the date of default, not necessarily when the debt starts. It's the date of default. It's the first time that they actually defaulted on the contract. So in this situation, they have a gym contract and they don't pay in January 2020. That's their first date of default. So that's when the statute's going to run from. So yeah, I'm sorry, Kat, go ahead.
I was gonna say, a lot of people use charge-off date as a possible date if they don't have a last payment date. But charge-off date, you have to make sure you're factoring in the window of time. Maybe it's 6 months, maybe it's more. So it's charge-off, and then you have to go back another 6 months, and you're presuming that default date, the date that they should have had a payment made, but they didn't, was probably within 6 months of the charge-off, depending on the debt type again. And so a lot of people do use the charge-off, maybe minus 180 days, 270 days, and then use that to calculate the years. So that chart gets more and more complicated depending on what you have. Because a lot of times, you open up a credit card and then you never make a payment. There is no last payment. They used it for a month and then just abandoned it. And 6 months later, the bank charges it off. So you don't have a last payment date. So again, rely on your attorneys to calculate these things depending on your exact account types. We love that answer. It depends.
Yeah, it depends. So
Yeah, go ahead.
I was just going to say, I had a quick question for Kat and Dennis, because we keep saying, well, check with your attorney, trust your attorney, everything. What about, local smaller collection agency shops, because this was something that was raised in the supplemental rule regarding time barred debt for Regulation F is the CFPB comfortable having lay people, non-attorneys, in these smaller collection shops make these legal determinations? And I think that was a big, at least from the National Creditors Bar standpoint, a big pushback on the comment, because do you want to leave that calculation for a layperson? I mean, we've just spent a whole hour and we've probably twisted everybody's heads 14 different ways. Do we want to let, Joe Schmo, who has this great little local collection agency, make that determination? What should he do?
Yeah, we did agree that Delaware has a 3-year statute of limitation. I think that's the only actual fact we provided. We didn't let you know when to apply the 3 years, but we did tell you that one thing as fact.
I know a lot of stuff. Cars isn't one of them. So if my car breaks down, I go to an auto mechanic. And if you can do statute of limitations and you feel confident, you're able to do the legal research and understand it and put it together and do it yourself. Or not, you can't litigate yourself, but you can understand the issue yourself and make those determinations yourself. But if you can't, then hire somebody who can. I mean, I think it's really that simple.
Yeah, and really it could be on your client too. Like, I definitely do my due diligence and then pass that information on to my service providers and hope that they, like I said, either you agree with me or you don't and you tell me why. And we have that conversation. But I really don't think the layperson should just, I think it might be this because I Googled it. Like, you should do a little bit more than that. And you probably are. If you're listening to us today, you're trying. So we applaud you and thanks for coming.
Well, because it also goes back to what you said, the policies and procedures. You don't have to have an attorney do look at everything all the time, but maybe at the beginning when developing your policies and procedures and help updating them. And then that gives the non-attorneys at your agencies the tools to make those determinations themselves.
Mm-hmm.
Well, Dennis, your last piece of advice was really good, because I don't know anything, which is why I get experts like the three of you to come here and answer questions about the statute of limitations. And unfortunately, we've run out of time. So Brent, Kat, Dennis, thank you so much for answering questions and for helping people sort of better understand this really nuanced and complicated topic. I really appreciate you taking the time to share with us today. Thank you.
Yeah, thanks for having us. It's been great. Thank you.
So
Thanks, Dennis and Kat.
TCN one last time for sponsoring today's webinar. Please go to www.tcn.com if you haven't already to check them out. You get the chance to share your thoughts about today's webinar and share any other ideas for the 20 upcoming webinars in a survey form that should pop up on your screen when today's webinar is over. We're back tomorrow with how to advocate in front of regulators and lawmakers. If you haven't signed up for that one, I encourage you to do so. We've actually got a representative from this Florida Assembly who's going to be part of the discussion today, sharing his perspectives on what he likes to see and hear when he's being lobbied. So sign up for that one if you haven't. Then we're back on Wednesday with 2 webinars because one a day probably isn't enough for me. We're talking about you've been sued under Hunstein, now what? And how to update your compliance management systems with respect to what's coming in Reg F. So you can sign up for those. You find the links in the events calendar on accountsrecovery.net. So hope to see you back for that. Until then, enjoy the rest of your day. Thank you very much, everybody. Really appreciate your continued support and participation. And we will talk to everybody soon. Take care.
Bye, everybody. Thank you.